Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss the 164 statement of any victim when to be given to the accused. Normally, you know the provision of section 207 CRPC, which we are going 207 and 208, which we are going to discuss in the later part of this video. The prosecution has to supply all the copies of documents on which it relies when at the time of filing the charge sheet. If you know this much, this case will be easily understood by you. Right. Now, in the case of X versus M. Mahender Reddy, in contempt petition 555 by 2022 on 1/11/2000, very recently. So, the Chief Justice of India bench U. Lalit, Bela and Bela M. Trivedi, right? They held that, please remember, the copy of 164 statement of the victim should be supplied to the accused only at the time of filing charge sheet, not before that. This is very clear decision. But what happened? Why this thing has taken up to the level of the contempt? Because already in the case of state of Karnataka Vs Shivanand, alias Tankari Shivanand 2014, Supreme Court has given clear guidelines. Of course, we are going to discuss the guidelines also. So, therefore, as the police did not follow the procedure, the Mahender Reddy has filed a contempt petition against the concerned officers. Of course, now they have come in appeal before the Honorable Supreme Court of India. Right. Here, the main important point is the victim of a rape case. Actually, the investigating officer got her statement recorded under section 164 CRPC. I think you know. So, what for 164 CRPC? No doubt, the police can record the statement of the victim under section 161 CRPC. Of course, it need not be signed. But if the same statement is given before the honorable judge, honorable magistrate, it will have sanctity. And you can take action under perjury because it is a signed statement. Of course, so many precautions will be taken by the justice. He will tell the concerned person, you need not give the so-called statement. So, but still, if she persists, yes. So, therefore, the 161 statement, once recorded, a copy of the same should be given to the investigating officer, not to the accused. The accused can get a copy at the time of filing the charge sheet under section 207 of the CRPC. Right? But what happened is, here the IO has got her statement recorded in the 164 CRPC. Immediately, the accused filed a petition before the court for supplying a copy of the same, and it was given to him. And this caused ire in the mind of the father of the victim, who is a rape victim, Mr. Mahender Reddy. He filed this to the notice of the Honorable Supreme Court of India. Right. Anyway, Supreme Court reiterated the guidelines. This is an important part, that's why I am only going to that particular aspect. So, the guidelines are like this. These were given in the case of Shivanand 2014 case. Upon receipt of the information regarding the case, that means a rape case, the IO shall get the statement of the victim under section 164 CRPC. Here the word shall, that means it is compulsory. That means it is concrete. You have to get it recorded. Of course, copy of the 161 statement can be given to the IO because he has to check up whether there are any corroborations, whether there are any contradictions, because once she goes to before the judge, she may speak something. If it is totally contradictory, then this man cannot file the charge sheet. Definitely, he has to get a copy of the 164 statement immediately. But it should not be disclosed till the charge sheet is filed under section 173 CRPC. You know, 173 CRPC is final report they will write, but final report is of two kinds. One is charge sheet, otherwise the referring the case like false, mistake of fact, mistake of law, undetectable and civil nature or non-cognizant, so many things will be there. So at the time of 173. Now, when you file the charge sheet, you have to supply the accused with all the copies of the documents on which the prosecution wants to rely. Then, after the filing the charge sheet is over, and it is given the so-called CC number, then when the accused is called to the court, then he has to be supplied with the copies of the documents under section 207 CRPC. At that time only the copy of the 164 statement should be given to the accused. This is the important point. Right. Here another direction is given that the IO, if as far as practicable, can get the 164 statement recorded by a lady magistrate or lady judge. Then please remember, IO should not give the copy to the accused person. Even the court should not give the copy. So please remember, to the victim, to the accused person only at the time of filing the charge sheet. And please remember, he should note down when he received the information, when he has produced the victim before the court for 164, and when he received the 164 CRPC statement. And please remember, if there is any delay in sending the victim to the medical officer for medical examination under section 164A CRPC, it has also to be noted. These are the guidelines. So, if anybody fails to follow the guidelines, definitely contempt action will be taken. Therefore, Mr. Mahender Reddy approached the Supreme Court for taking contempt action against the state. But of course, Supreme Court said they are not going to look into the contempt petition. Only thing is, the police or the lower court should have followed the directions. Once again, the directions have been reiterated. So please, all of you should remember these guidelines. But here, one legal point will come. Is the accused not entitled to get a copy of the 164 statement? Certainly yes, but only when the time is when? At the time of filing charge. Normally, same thing will be done, right? Anyway, good judgment by the Apex Court of India. So therefore, you have to follow the guidelines also. Please remember the guidelines in the case of State of Karnataka versus Shivanand 2014, as well as this case also. So with this, I am stopping. Thank you very much.